to privacy. Information which you normally would not share about your health, about other things, would be related to invasion of privacy. But the other things will not be covered under this. And therefore, as far as the public interest part is concerned that Shekhar mentioned, out of the 10 exemption clauses, 3 exemption clauses mention private public interest. This I think has been a drafting error because section 8(2) gives the top of public interest being an override to all the 10 exemption clauses. So therefore, my personal perception is we need not bother about the public interest being mentioned in 3 of the 10 exemption clauses. Section 8(2) anyway talks of public interest override. When there is a public interest override, then of course you will ask the appellant to justify the public interest, in which case the question of purpose will come in. But otherwise, reading anything specific in this public interest clause, which is in this subsection, is relevant because it's also there in 2 other subsections. And since 8(2) provides a complete override to section 8(1) in terms of public interest, whenever an exemption is claimed, the appellant can justify and say there is a larger public interest, which he will have to justify. Then, of course, he'll have to disclose the purpose of asking for this information.
Interesting, Shailesh, actually, that you are interpreting person in terms of the individual human person. That's one very important thing. Because I think the General Clauses Act will say person will include also legal entities and so on. So that's a very important development to make in the law as far as this is concerned. To depart from general law and say person means the individual person. The corporation and so on will not have any. The second is, if there is a public interest justification for 2J, then the answer to somebody's question here a little while ago, can you ask for information relating to the spouse of an employee? And then you say, all right, the justification for that is, I believe that money illegally earned is being put into her account or put into her son's account and so on. Then you might justify even asking for the spouse's details or the son's details and so on and so forth. Personal information, but this is my justification. Then if you take the defense of privacy, privacy would mean legal privacy. That is to say, all your private actions
and children. Having said that, I cannot see any argument which says that those who want to be public servants must declare, but those who are public servants need not. I mean, I find the argument completely fallacious. It's only because the courts, when they suddenly realize that they are public servants, have started taking a different viewpoint.
Sir, Mr. Rana, the conduct rules envisages filing of annual returns, property returns, in respect of the employee only, and not about their spouses or major sons and daughters. So the public authority may not be having the details of the property of the wife of a particular employee or the son and daughter of a particular employee. In that situation, I don't think the PIO will be able to furnish the details of the property of wife or son and daughter of the employee. Because it's not obligatory for any employee to submit the details of the property of his wife or his major son and daughter.
So that's fair enough. I mean, if you don't have that information, there is no problem. Yeah, can I just flag another issue here with the same thing?
Sir, can you quote me the relevant portion? Because service conduct rule says family assets. It has clearly says family assets, not personal assets.
Nowhere it is mentioned.
I will be rather pleased, sir, if you can quote the relevant portion, or if you can mail me the relevant portion.
It does not say family assets. You go and read it.
Yes, it is family assets, sir.
Okay, we'll sort this out at lunch. I just wanted to flag one very interesting case which the Information Commissioner from Mizoram brought to my notice, and of course we all know about it, and that is the Arvind Kejriwal case, where he had applied for information relating to the promotion of officers to joint secretaries, additional secretaries and secretaries of the Government of India, and on what basis were these promotions, etc. I mean, the CIC held that this should be given to him, and in fact he started the process of accessing this information. But meantime the DOPT went to the High Court, and the High Court said no, this should not be given. Now this is a very interesting case, because on the face of it, there seems to be a lot of public interest in trying to find out Who are the people who get promoted? On what basis? Who are the people who get posted to? I mean, how did this gentleman get posted as director in the Home Ministry, in the Internal Security Division, which is the most sensitive post in the Home Ministry? So we want to know. We also want to know what is wrong with the system. Was it collusion? Was it incompetence? And you cannot know this unless you know these. But the High Court held this. So what I'm trying to say is that therefore this whole privacy thing, I think, has become the sort of bugbear where one is simply saying, no, but this is something that the public has no interest in. I think the point that we need to make is that anything that is a matter of good governance is of public interest. That is the preamble of the thing, and therefore if it helps us to make sure governance is better.
I agree with Mr. Singh. Just imagine a situation in a terrorist affected area of a state and of the country. If somebody goes and asks, and we hear that in certain northeastern states, government officers have to pay regular ransom to certain groups. Supposing somebody goes and says that please give me the immutable property return, copies of the property returns of the X set of officers. Or a thief goes and says that he would like to have the details of what property you have or income tax return you have so that he can plan adequately to access you when you are not very careful. So I think that there is some merit in the decision of the CIC that certain information like about your body, the property and the body are the property of a person and his body are similar. So therefore the property of an individual, unless there is a CBI inquiry about him, about his disproportionate assets, in which case it is in public interest that this matter should be disclosed. That is the view which you have taken.
No, on this, the example which I just took in the beginning by way of introductory remarks regarding the whole body scan, total body scan, and the Harry Potter's invisibility code comes here. So this is the kind of borderline we learn to draw. So it's purely subjective. It cannot be an objective kind of a decision as far as this is concerned. What is personal? My perception may be totally different from what Mr. Jacob Singh says or we say. So, well, this will be debated ad nauseam, I don't know.
Can I just, in response to Mishra Saab and your points, see, as far as your first case goes, where somebody in the northeast or Jharkhand or Chhattisgarh is under that pressure, we have 81G, which specifically says that you can withhold information which the disclosure of which could threaten somebody's life or physical well-being. So the onus therefore is on that officer, because there is a third party clause here. So third party, suppose I ask for the collector's thing, the collector has to be asked under third party clause. Collector can say, look, ordinarily this is available, but in this circumstance it would threaten my life, etc. And if he can make a case or she can make a case for that, fine. Now, as far as your second point goes about thief, this is very often used also against income tax. In fact, the common thing is that if you make people's income tax returns public, then the extortionists and the blackmailers will know who to blackmail and whose children to kidnap. My argument is you don't need income tax returns. You just have to walk out and look at the colonies, and there are 4 Mercedes Benzes standing, and there are enough people who show their wealth in India today. That's so why should I, if I was a thief, Mishra Saab, I would not look for income tax returns. I would look for the colony the guy is staying in, the sorts of cars he has. So what I'm saying is that we could always find certain exceptions, which will always happen. But in general, it seems to me that if you invoke 8.1, of course, Shailesh is vehemently objecting to it, can we accommodate?
Okay, my view is that then, by the same logic, in Jharkhand and various states like this, those who stand for elections must also be exempted. See, we cannot have this double standard. If those who stand for elections, even for a Panchayati Raj, must declare his assets, and some people must not. Those people will not be able. Even a person who wants to stand for an election, I think this, to my mind, is
standing for election and doing it. There is I think that the definition of public servant covers everybody. But there is a great difference between an elected representative and a permanent civil servant. So let us not distinguish. Block the distinction that clearly exists between the elected representative and
Let me also further say. Sorry.
Excuse me. I think regarding the notice you are saying, I think other notice commission, they will also agree. Regarding this extortion, that by knowing information, I think this is just an excuse.
because this underground people, so-called, they knows very well what is going on, who is what, how much has, even government decision, we don't know, but they know. So that way, I think this is just
You don't need a right. If everybody knows everything, you don't need a right to information act. I mean, this is a very absurd argument to say that because
Why don't authenticate that information? That's what he said.
That's it, you see, now. Right? Information is, you see, people who knows, I know this is this, but just to get authenticated, I may file RTA application. So you cannot say that we don't have RTA application, because by knowing information, by getting through the PI or public authority, it has got a lot of difference. So I think
Shashank,
it
the
is not
government has leaked like a sieve from much before the RTI Act. I have had this problem that I've got all the documents I want, but I can't present them because I've got them illegally, so I have to get them through the.
On me.
But let me also mention the Shailesh's point. I don't agree with you, Shailesh, because see, the law at the moment says that people who are standing for elections have to give this information to the election commission or the state election. I don't think the law says that this has to ipso facto be made public, because if you remember, the RTI was used by the various NGOs to make this information public, the NCPRI itself in the first elections. Now there, the Information Commissioner can apply that same thing, which is applying for officers. If he feels it's legitimate, it can be applied. I'm not saying it's going to be easy. You see, for example, it will be difficult even for a civil servant unless it's exceptional circumstances, to argue successfully that, look, if my assets get to be known, I'll come under additional threat. But where, I mean, let's keep this open as a possibility. Where that happens, yes, it should apply to, it should even apply to the.
See, in the Ramana Loya hospital, a lot of people get treated like any other government hospital. The government public money is spent on the patients. So can one go and ask that what are the various diseases for which Mr. Sekhar Singh or Satyanand Mishra have been recently diagnosed? Give me the copies of that. No, that's not fiduciary relationship. That is, I mean, a fiduciary relationship would be with a doctor to whom I am paying my own money and getting treated. Here it is a public hospital. The public is spending. Where is it mentioned that the public? I mean that this information which I am giving to the doctor is in trust.
Yeah. See, this is a very interesting case. Let me just mention this, with your permission, Chairman. That see, there are two sides to it. On the one hand, I totally agree with you that why should anybody know about my health conditions? I am not a public servant. I am not sitting where if I was died tomorrow, it would make any difference to anybody. But there's a problem. For example, I remember in Rajasthan we had these public hearings about hospitals, the primary health centers. Now, what would happen is these hospitals would get medicines which were supposed to be provided free of charge to the patients. They would actually sell all this to the shopkeepers. They would maintain a fictitious register saying Mr. Mishra was given this tablet and Shekhar Singh was given this tablet. So when you go in and say this is how there is no medicine, you go and buy it from the shop and get it. So they would not only sell their medicine, they'll also get a percentage on that. Now, we as RTI activists went there and said, well, you give us a copy of the register because we want to go and ask those patients whether they actually got those medicines. Fortunately, they didn't think too hard and they gave it to us. When we went, we found that 90% of